Okay, good evening, folks. Welcome. Thank you for joining us here at the School of Advanced Study at the University of London. My name is Corinne Lennox, and I'm Senior Lecturer in Human Rights at the Institute of Commonwealth Studies and the Human Rights Consortium. Thank you for joining us today for this seminar on a uniform civil code, stakes for Indian democracy. We have folks in person here and also online, so thank you to those who are joining us in both spaces. Just for your awareness, we're recording this session, but only the portion of the lecture, so the discussion will not be recorded. The Institute of Commonwealth Studies and the Human Rights Consortium have common interests in a number of key human rights issues. Personally, I work on the rights of minorities, so I'm particularly interested also in this topic today. And the Institute of Commonwealth Studies is pursuing a number of important areas related to the topic, including rule of law, which is intersecting with our focus today. So we'll have about half an hour talk from our speaker, and then we'll have a chance for questions and discussion. Those who are joining us online, feel free to put your question in a chat, and I'll do my best as chair to relay that. So let me first invite a brief introduction of our guest today, Professor Arundhati Virmani, who is a historian based at the School of Advanced Studies in Social Sciences at Marseille. She's trained in European history with a PhD in 19th century French history at the Sorbonne, and then she reoriented her research to colonial societies. Her works on transformation of cultural and political practices from the colonial period to the contemporary period, focusing on questions of national construction and political cultures that encompass cultural and social practices. She is widely published in English and in French, including among her publications A National Flag for India, Rituals, Nationalism, and the Politics of Sentiment, a number of historical volumes in French concerning the history of India. Among her edited books is Political Aesthetics, Culture, Critique, and the Everyday, and a forthcoming edited book with Jean Boutier and Manohar Kumar on social scientists and the civic space, ethical principles on democratic involvement, which sounds like a good background for what we're talking about, what we're doing here today, in fact. So with that, I'd like to invite Professor Virmani to share with us her thoughts. Thank you.
Thank you very much, Corinne, and thank you for hosting this talk. I'm quite delighted to be here in the Institute of Commonwealth Studies because it kind of moves my political space away from France into the Commonwealth, where kind of more classically we're part of. And so today, I'm happy to share some thoughts on the project of a uniform civil code in India. A lot has been said and written about this question, and it seems to have been hovering like a dark cloud since India's independence. It's never really receded from public or political attention. And if you do a rapid survey of the literature and the coverage on this question, at least I looked at JSTOR, social engine, and I found more than 1,750 articles on this, indicating that the Uniform Civil Code is really a very central subject, but not only for India, but it's more broadly so because it's marked a critical stage in many national histories and continues to do so today in Europe. So from France in the 18th century to Europe today, and in India, it's particularly relevant today. So in the Indian context, we're thinking about the Uniform Civil Code, which refers to personal law that is related to family, marriage, divorce, inheritance or adoption, and it's become a problematic knot to redefine citizenship, but also because it's so closely tied up to many other critical issues, religious practices, identities, minority groups, tribes, Muslims, Christians. It links up with expectations also about the beginning of a new India, or fears and apprehensions that it's simply serving as a vehicle for Hindu majoritarianism and inaugurating a slide away from pluralist democracy, which has been the foundational basis of the Indian nation. So the matter really acquired fresh urgency in June 2023, when the Prime Minister stressed the need for a uniform civil code to the Bharatiya Janata Party workers. And political reactions were immediate. The Rashtriya Swayamsevak Sangh claimed that the Uniform Civil Code is absolutely essential to foster unity. And some states, some of which also reacted warmly to this idea. Some, like Uttarakhand, had already set up panels to explore the possibility of a common civil code in the state. They'd already launched consultations, 13 months of consultations in Uttarakhand, public meetings, but no report yet. And so meetings with a lot of people via public outreach programs. Other states like Gujarat, like Uttar Pradesh, were setting up panels and committees to look into this matter. Very often these panels were being presided over by retired Supreme Court judges. Madhya Pradesh Chief Minister said that a committee would be constituted to look into the implementation of this Uniform Civil Code. I'll call it the UCC in the state. I think we all understand. And the Meghalaya Chief Minister welcomed the move as well. But on the other hand, the opposition was also very strong and vibrant from the Congress, which stated that it would await the draft of the code before it took any position, but that any uniformity must respect diversity, which was the foundational principle. But other states like Tamil Nadu, which have non-BJP governments, called it merely a diversionary tactic. So it's been considered as an electoral ploy for the next year's general election. And there were strong, very sharp reactions from the All India Muslim Personal Law Board, which criticized it sharply. It sent in a 74-page report, termed the exercise politically motivated, that was aimed at polarizing and dividing the citizens on religious grounds to achieve political mileage for the government in power. They considered that it put the Muslim law in peril. It was an attack on their identity, and it declared that it was not feasible. It worked against India's pluralism and diversity. So you had other Muslim groups, the Jamaat Ulema Al-Hind, which is India's largest Muslim organization, which also stated that it's going to impact the unity and diversity of India. So other states like Nagaland, for example, expressed their fears and their opposition to this project. They saw it as a direct threat to, in apostrophes, our customary laws, social and religious practices that govern every individual in their society, and they sought exemption from the UCC. And in fact, this kind of opposition led the current government, to say that some tribal states and that Christians could be exempted from the purview of the UCC. So some kind of clauses were being accommodated. And these kind of responses, passionate, immediate reactions, are not new, because since the idea was actually debated in the Constituent Assembly in India in 1947 to 1948, it aroused a great deal of passion, and it had been in the front line of political, judicial, and civil attention. So I'm going to proceed in 3 steps. And first, I'm going to just recall rapidly, because perhaps you're all familiar with this, and if I sound too simple, I apologize, and you know it all already. So I'm going to just recall the long and historically rich genealogy of the UCC. Then I'm going to examine some of the factors which have made the UCC an impossible judicial utopia. And thirdly, I'm going to view the UCC in a larger global comparative context. And I think this is interesting, the third point, really, because just the other day, on 19th November, the Chief Justice of India, D.Y. Chandrachud, in an interview with the Indian daily Indian Express declared that India is not isolated from other parts of the world, that humanity works on certain well accepted and common constitutional principles. And there are certain constitutional values which are universally accepted. And this sort of helps us to really consider India's project for a UCC in a larger global frame, I think, not to compare it with other national histories of the UCC, but with the ongoing debate on a European civil code. And finally, I'm going to conclude with the possible implications of this for Indian democracy. So, very briefly, the historically rich genealogy of the UCC. It's really, a mosaic of personal law systems. It's a product of historical growth, royal interventions, and colonial legislation. I think we're all familiar with this, that, India presented a complex picture of religious personal laws and colonial judicial system. I'd just like to point out that whilst under the Mughals and the British criminal law was unified, personal laws continuing to function in the greatest regional variety. But so we know the British system. Warren Hastings had a judicial plan in 1772, and this provided uniform courts of law on the civil side in eastern India. They could apply personal laws of different religious communities, but this already demanded a certain amount of codification of the diversity of systems that were existing in Hindu law, but also in Muslim law. So some kind of codification did occur at that time. And after 1781, you find that three systems of law were at least functioning: the Hindu, the Muslim, and the English, at least. Then the Portuguese introduced the Portuguese Civil Code of 1867, which they had itself been inspired by the Napoleonic Civil Code in their colonies, Goa, Daman, Diu. And then we had a very different situation in the French establishments, where a movement by some Indian colonial subjects of these establishments had led to the option of offering them the coverage of the French Civil Code. And so that was also a very complex situation where some people renounced their own personal laws and opted for the French Civil Code, thinking that it's going to give them the full rights of citizenship, which it didn't, but gave them some rights. And so this is a plurality of personal judicial systems in each case of in each colonial context. And therefore, there's this kaleidoscope of regional variations, traditions, and customary laws that India kind of inherits when it turns towards independence. But independence doesn't bring about any dramatic break or rupture, because the Constituent Assembly debates from 1946 to 1950 showed that law, far from being a field of reason and judicial logic, was completely enmeshed in politics and social tensions, not to say passions. And debates involved lawyers, politicians, social reformers, women, and they revealed all the tensions between the new political body of the nation and loyalties to the community. So on the one hand, there were champions of one nation as a unique source of law, a political body that would transcend all particularisms and regional attachments, where personal laws would be subordinated to a political, arbitrarily defined system of jurisprudence. And on the other side stood defenders of a judicial pluralism of civil laws, particularly Muslim and Christian representatives. So this was a major rift, which created a political stalemate. And finally, the idea of introducing the Uniform Civil Code as a law in the Indian Constitution became a directive principle. Article 44, that is, it was not mandatory or enforceable in a court of law, but it said that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. Now, there were a lot of arguments and pleas, on the grounds of social justice, equality, especially for women, and nationhood. Strong nation needs a united civil code, which was the pattern for many countries uh, in their trajectory to nationhood. Um, and there were lawyers keenly involved in this debate, but also many Muslim representatives who opposed the project, saying that personal laws were very much part of their religion. And this was refuted by other constitutionalists like B.R. Ambedkar, who pointed out that, yes, every aspect of daily life was enmeshed in religion. In that case, the state would not be able to intervene. But anyway, the result was that the UCC remained a directive principle. Now, since the 1950s, well, this is the right. So, since the 1950s, then the project of a UCC, I said it's been hovering like a dark cloud, really, in the horizon. It's never receded, either because of government announcement, but also because of judicial rulings or judgments. And these, in turn, have triggered responses from different actors, social scientists, of course, who have written greatly on the question, but also jurists and feminists. So I'm not going to read out all this. You can see that there are a large number of court rulings in the 1970s and in the 1980s, especially, which have been a primary source for keeping attention focused on this project and raising the question of, are we going to do it finally or not? And so this brings out really a practical aspect of why it is necessary. It would simplify rulings. It would simplify judicial decisions. And so we can look at these series of decisions in each decade, in the 1970s, in the 1980s, and in the 1990s. And each decade has a significant and important judicial ruling that is occurring in a political context which shouldn't be sidelined, which has its own problems of, pragmatically dealing with the question of management of India's diversity and its political differences and the different alliances. So these court rulings must be considered in that political context of, say, tensions from the states, from the Northeast, from the West, or from the South. And they must be considered in that context. So here are some of the decisions, Supreme Court judgments which said, yes, we should think about a UCC and finally adopting it. And then you have other Supreme Court judgments which say that we really don't need to think about a UCC, and we can, work within this context. And that, for example, freedom of religion is the core of our culture. So even the slightest deviation can shake this social fiber and weaken this structure. And at the same time, so it's an important dimension because here you have opinions by judges, retired or active Supreme Court judges. And this is not only in judgments, but also they're expressing their opinions in forward to books, in judicial pronouncements, of course, but we can take them as an example of a declaratory judicial remedy. Now, I made a slide on some of the legal voices in favor, so we can look at some of the arguments they are mobilizing. One of them, Justice Ratnaparthi, who said that, yes, it's not only feasible, but it's immediately necessary, and it will bring unity to a fragmented society. There's no need to delay this project. and that the plurality of laws is considered as a direct threat to national integrity. But on the other hand, there are other voices against that. It's not feasible in a country like India because it would mean that communities lose their rights and privileges, and that it's contradictory to the fundamental rights guaranteed by the articles in the Constitution. And amongst all this, you have of course, the very strong positions by the All India Muslim Personal Law Board, which has written regular memorandums warning the government against any interference with its religion. But most interesting in this, set of voices. So you can see that there is a very wide range of voices and opinions about this, both technical, informed, legal, but also from different quarters, and it's more broader and broader, and it extends to civil society. Now, a very interesting set of voices comes from the feminists, of course, because the question had been at the forefront of women's struggles for equality and justice, and their main preoccupation was, what's in it for us? Very natural, will it be pro-women? And so in 1937, the All India Women's Conference had felt that a UCC was desirable. But by the 1990s, its position had changed to reform in each religion's personal laws. And that these laws, personal laws, should be more just for women. For example, the divorce laws for the Indian Christians, that resulted in the Indian Divorce Amendment Act of 2001. And then there was the Domestic Violence Act in 2005. So we must also remember that this is a period in the 1990s, a growing strength of women's groups, civil groups, activist groups, and this is gains tremendous strength. And they're very vocal about common, gender, just, egalitarian civil laws, not just a uniform civil code. And there's a big debate. We could, sort of go into that. I have 7 minutes.
We'll be generous.
Yeah. Right. So these are interesting positions amongst the feminists, because amongst them you have Ms. Chaban, who's not in favor of the UCC, but that, they consider that it's a political tool in the hands of political parties. It consolidates certain votes and creates critical attitudes towards other minority communities by considering that they're not advanced enough or progressive enough, and that they should certainly move on to the path of modernity. There are others who call for personal law reforms and gender empowerment. So they say that minority, like Ms. Kidwai, who insisted that wrote a lot about how it was necessary to have an urgent reform of Muslim personal law, and pointing out that it was in fact Muslim law as codified by the British. And so it had already undergone several modifications, and there was nothing really authentic about any kind of this law. And also that a UCC wasn't practical because there were many differences from region to region and community to community, and it was better to amend personal laws and not touch religious law, because anyway the power of social custom was stronger, she said, because although the Hindu personal law had been reformed, it was still not being applied in many respects. Now, on the political level, we've looked at it at different groups, and on the political level, of course, the change in governments in power brought the project of a UCC to the forefront. The Bharatiya Janata Party's victory in 2014 changed the landscape a little. In 2019, this became one of its electoral promises. And in the following decade, it took some concrete measures. The 21st Law Commission was set up and actually deliberated on the reform of family law. It gave in a 185-page report in 2018, but it concluded that the UCC was neither necessary nor desirable at this stage. But then another law commission that was set up in 2023, and it invited responses from various stakeholders, from religious groups, from political organizations, and from the public. And it said that it would even consider suggestions from Indians living abroad or foreigners who it felt could give valuable suggestions on the feasibility of the issue at hand. The deadline was extended because it got so many responses, and it got more than 7,500,000 responses. And it even received a draft proposal finally. So actually, I wanted to show you some of the questions, it diffused a questionnaire to which people were asked to respond. And it received a draft proposal by a citizen group. And it's interesting to see that this citizen group was composed of two historians, a retired military person, a musician, an actor, a lawyer, and an activist. And so it's interesting to see. I'll come to that when we compare it with with the European Civil Code, that the voices are very different. And so they have given in a draft proposal, and this has been submitted to the Law Commission, and the Law Commission is now to submit its report to the government by listing a series of recommendations. That hasn't been done yet. So as we can see that debates and discussions on the UCC have been very extensive and prolonged, and many of the arguments and the stakes have turned around fundamental rights, liberty, constitutional guarantees of pluralism, protection of religious identities, and principles of social justice, equality, state responsibility towards women and minority groups, etc. Now, neither the course of this debate nor the ideas and principles of justice, equality, gender justice, fundamental rights is unique to the Indian case. If we look at other nations, they have all gone through this and when they adopted the Uniform Civil Code. And France is the most striking example, of course, where it took almost 15 years from the 18th century onwards to enact a Uniform Civil Code. And in fact, the famous revolutionary Cahier de Doléances in 1789 didn't have any demand for a uniform civil code at all. And they didn't want a unity of law. They were more concerned with their local grievances. And it was only, other enlightened opinion in France that was in favor of unifying French private law. And it actually took 15 years of great discussion in which different influences intervened, of philosophers, of lawyers, of politicians, who argued from various perspectives of liberty, authority, equality, and order. And finally, the Napoleonic Code, which is called the Napoleonic Code, but actually there's a lot of debate about whether, Napoleon simply inherited something that had been discussed for many, many years. He certainly assisted in all the debates, but he actually watered down the projects. And so it's kind of exaggerated to term it the Napoleonic Code. But anyway, he's the one who introduced it, and to him went the credit. And then the French model was, of course, adopted by many other European countries and even outside Europe. But although other national civil codes offer interesting parallels about debates and the difficulties of compilation, I find that the nature of the ongoing debates on the European Civil Code provides a more immediate and interesting model for comparison. And this is one of the major judicial challenges of contemporary Europe. It's hotly debated, defended, contested, but mostly by jurists in study groups or research groups. And then it's commented a little bit by politicians. But in comparison to the UCC, this is almost a very technical and a very judicial debate. And, there have been many commissions. It really took off in 1989, after which there was a succession of committees, who gave their recommendations, beginning by a Dutch committee, then the Italians, and so it's moved across Europe with every group of jurists offering their own viewpoint, even the British, who defended the common law tradition, of course. So there's an economic aspect to this, and to support the unification of civil legislation, but opposite this economic argument, there's a cultural argument that opposes unification. So this is very interesting, and we find the similar concerns and antagonism. So there is there's a strong argument that plurality of convictions must be safeguarded. And this is a permanent feature of public culture of democracy, as posited by the philosopher John Rawls. So the project for a European Civil Code is seen as an attack on pluralism. It sort of raises a specter of Euroland. And we find the same fears that unity will become a means of effacing other cultures. It will reduce the diversity of legal discourses, because the argument is upheld that each legal tradition has its own rhetorical force. And so a European Civil Code would actually limit alternative visions of social life, and it would have the effect of what Bourdieu called, the French sociologist Pierre Bourdieu called, a codification effect. That is, it would encourage a sense of closure. And that, what is found in the text, it has been finalized, it has reached a state of completion, and it would monopolize legal discourse. So the idea is code stands still while life moves on. And that's the argument. So it's also criticized for being too arrogant and for suggesting that the civilian representation of the world is more worthy than its alternative and very superior, so that it deserves to supersede. I think all these arguments are very interesting because we find that there are many echoes and it resonates a lot. And so in the current context, what the French philosopher Jean-François Lyotard calls the postmodern era, which actually kind of reveals an incredulity towards meta-narratives, big narratives. This appears to be a kind of a civilizing project. So the question that's raised is that, are we, in India, are we doing a re-civilizing project? And that becomes an issue itself, that therefore it's utopian. And these arguments, which are voiced in the frame of Europe, far from being alien or foreign, actually resonate, I find, very strongly in the Indian context, because both reveal a deep concern with the interpretation of the right to liberty, justice, and equality that lie at the heart of democracy. So I'm just going to conclude. I've overshot by perhaps 5 minutes, but that's kind of excusable. So, I feel that India stands a little bit at the crossroads today. Having asserted itself as a nation of diversity, it could now opt for an undivided, united nation. And over these last 70 decades or so, the UCC project has revealed an unease, the difficulty of reconciling two dimensions of the individual and the collective, according to which social actors think out their projects and their constructions. And democracy must actually integrate this complex dimension. It's a balancing act between becoming plural in the forms in which it cloaks itself. So the implications of UCC for Indian democracy cannot be exclusively evaluated in terms of national consolidation or short-term political imperatives and agendas. Larger issues are at stake for the practice of democracy. Faced with the plurality of communities and the diversity of interpretations within these communities, the principle of equality that lies at the heart of democracies carries the corollary also of equal respect of people and their convictions. So the democratic principle of equality calls for equal respect of persons and their convictions. And democracy actually implies a deft management of differences in the assumption of pluralism, acceptance of coexistence of non-harmonized rationalities, in the steady practice of a politics of inclusion. And so you have a kind of choice of cultural pluralism or a brave new monotony, perhaps. So finally, I feel this entire debate, I see it as a platform to enact a dynamic process of democracy. It's an open platform for expression of opposing views. We've seen of arguments and counter arguments. And this exercise, really, the entire debate, not so much as its conclusion, where there would be a conclusion or not, but this whole exercise appears itself as a very important democratic process, large-scale consultation at every level, states, institutions, individuals, professional bodies, experts, intellectuals, civil society organizations, groups giving their drafts. And as compared to the act of voting, I feel this is a very long reflective process, which is not insignificant. It's lasted at least several months. So it reiterates democracy not as a regime, but as a process. And it calls for confronting tensions in order to integrate them. And this seems to confirm the idea and practice of democracy, which is, if we consider it as power of the people, but a people who are multiple bearers of contradictory, socially diverse identities. So whatever the result, this act of consultation, this free and open expression is, I feel, a cornerstone of democratic systems, even if this is by a dominant fraction. But if we look at a little YouTube video I have downloaded, perhaps we can do that in the discussion. We'll find that it's an exercise in outreach of people. There is an alternative recommended by Nietzsche, who said, handle deep problems like cold baths, quickly into them and quickly out of them. And that's a risk we will be confronting now. Thank you.
Thank you so much.